SJC-12684, Robert Marley v. Corday and Associates.
Mr. Marley, good morning. We can see you as long as you continue to sit. So please remain sitting. If you stand for some, the camera will not, will grab only your chest. So you've got 10 minutes, sir. You may proceed.
Good morning, Chief Justice Gantz, Your Honors. Can you hear me okay?
Yes.
Yes.
Okay. May it please the court, my name is Robert P. Marley, pro se appellant in the instant matter. I apologize for my current predicament and my inability to appear personally. My wife is in the courtroom. She's present. Before I begin, I need to make the court aware of what has transpired since I filed this appeal. When I went before the single justice in the county court with my petition and counter complaint, I filed a TRO, and that's the reason I filed the counter complaint in support of the TRO. The day I left the court, counsel Thomas O'Neill called me up. He was aware that I filed it, and he said to me that he would agree that there would be no more foreclosure action or auction as it related to our property. I asked him for that in writing. He said, I give you my word, there'll be no auction on the property while this matter is pending. I said, okay, I'll call the single justice clerk and have him cancel the hearing on the TRO. And I did that. Once I filed this appeal, things started to change a little bit. Counsel had given me a courtesy call that told me that his clients were going to attempt another foreclosure while this was on appeal. Of course, I was a little bit irate, and subsequently I wound up where I am today, unfortunately. But while I've been here, Corday and Associates skullduggerously took it upon themselves while this was on appeal to auction our home off. So that's where we stand today, Your Honor. As far as that's concerned, they went forward with the foreclosure and they auctioned off our home. They horrified and terrified my wife, my children, in front of all our neighbors. I don't know all the particulars as to what transpired, but it was even my understanding that some of my neighbors were outside in the street crying when they auctioned off my home. And that's all I wanted to say before I got to our oral arguments. And the tactic really was to force me to file yet another complaint in the TRO in Superior Court so that they could remove my case once again to the federal forum where I'd receive no justice, as the record clearly demonstrates. So I will move along with the argument. And, you know, I have to say one more thing. My wife explained to me how my children were as they watched them auction off our house. They were devastated. And God only knows what the long-term effect on my children will be because of what they did. And I wasn't there to protect them because I'm here. And I would ask that the court today instruct counsel to stop all process, because I'm sure the next step is the summary eviction process, which I can't really defend in here. I have no adequate access to the law, to the library, or any current legal material, unless an order comes from the court to this institution instructing them to give me pro se status in the law library. But based on promissory estoppel, what they did should be void as a matter of law. And I would ask that the court void that auction and that foreclosure. I'll begin with my argument, Your Honors. With all due respect to the single justice, Justice Budd overlooked some legal arguments in my petition and my counter complaint. First, the single justice stated that I admitted that I had stopped paying the mortgage, and that's true. The 2008 bankruptcy terminated the debt, regardless of what happened since then. The debt was automatically extinguished as a matter of law, so there was no more debt. The note was gone. It might still exist. Did they have recourse at law under the note? Sure they did, absolutely. Well, they didn't do anything. They had 6 years to enforce the note. They didn't. But there was nothing to pay. And for 2 years, I felt like everybody else, you know, I was as ignorant as the rest of the world until I did an investigation. I studied the securitization process and found out what they really did. But I was as ignorant as the rest of the world, and I felt after my bankruptcy that I had an obligation to continue to pay my debt until I found out what they did. Then in April of 2009 or 10, I sent my last qualified written request in demand letter under the Fair Debt Collection Practices Act. I demanded I wanted to view the original promissory note with all the required endorsements down through the securitization Ponzi scheme, from the original lender to the one who claimed the right to foreclose. And I might add right now that Bank of New York Mellon is not a mortgagee by any definition of the law, and they're not. At most, they might be a trustee on behalf of the certificate holders who bought a fractional share in a note and a mortgage, albeit without any negotiation, delivery, assignment to each one of those certificate holders, or an assignment of the mortgage in writing as required in Massachusetts to those fractional certificate holders. And I guess maybe they would be a mortgagee if there was an assignment to each and every one of them. I don't know. But Bank of New York Mellon certainly isn't a mortgagee by any definition of our law. But at any rate, as far as the single justice is concerned and the issues that I raised, it was part of her reasoning for dismissing the petition and the counter complaint was that I admitted I stopped paying. Under the statute, Massachusetts General Laws, Chapter 106, Section 3-5012, once I demanded the note with all the required endorsements and proof that they had the authority to act on behalf of the note owner, and Bank of America refused to do that, I was within my legal right, as it states in the statute, to stop paying without dishonor. So I did. But you can't lose sight of the fact that there was nothing to pay anyway because the debt extinguished as a matter of law by bankruptcy code. And according to the bankruptcy code, the moment I filed my petition in 2008, September 30th, all my debt accelerated as a matter of law. That's in the code. That's the law. That's the specific language. All date accelerates on the petition date and becomes due and payable immediately. And so the maturity date and the terms of the mortgage and the note, and there is no maturity date on the mortgage. The maturity date is the note, and this court, in an articulate ruling in Deutsche Bank versus Pittsburgh, they made it perfectly clear the relationship between the note and the mortgage. The mortgage doesn't survive without the note. Once the note is gone, so isn't the mortgage. And as far as the counter complaint goes, I don't think the single justice gave that any consideration. I brought the counter complaint based on the rule, Massachusetts Civil Rules of Procedure, Rule 13, which states that I had to bring my compulsory claims, all my claims for that matter, and any legal matter where it was related to the original matter. So Cordy and Associates moved on behalf of Shell Point Mortgage in the land court. And I have to say that Shell Point couldn't move in the land court because Judge Lang gave Shell Point the opportunity, when I had filed my petition in the Essex Superior Court for a judicial discharge of mortgage because they wouldn't relent, and there was no mortgage to enforce, there was no power in sale to enforce. The mortgage had already discharged as a matter of law pursuant to Massachusetts General Laws 260, Section 33 and 34. However, they failed to recognize that, and counsel believes that that law is not applicable to this matter. And it is, because an acceleration terminates even the mortgage itself in paragraph 19 and 22 states that once it's accelerated, the mortgage is terminated. And the only way it can be reinstated is to comply with the conditions set forth in paragraph 19 and 22. But at any rate, the terms of the mortgage and the note terminated on the bankruptcy date, September 30th, 2008, and more so, the acceleration date of May 8th by way of the April 8th, 2010 notice of acceleration. And there's a case that I have, right here that states that, because I'm sure council's gonna raise the issue, whether or not this was accelerated, but this is well-settled law. According to the mortgage must make a positive act and make an unequivocal declaration to the mortgager that it is exercising its option to accelerate. See Strong versus Stoneham Co-op Bank, 357 Mass, 662 at 667. Bringing a foreclosure action with sufficient exercise of acceleration option. Then see, and this is case on point for me, Your Honors. See,
Okay, Mr. Marley, your time is, Mr. Marley, your time is up, so why don't you finish up in the next 30 seconds, if you would, please?
okay, so a letter from the bank to the mortgages pointing out the default, explicitly exercising acceleration option was sufficient. So when they sent, even though it was already accelerated, they sent that second letter accelerating the debt. The terms terminated in the mortgage, gone. And in the note, so they had 6 years to enforce the note. They had 5 years to protect their saving grace period by filing the acknowledgement or the affidavit in the registry of deeds that the note was not satisfied. They never did any of that. As a matter of law, the mortgage discharged, I would say, in 2013. But at a later date, 2015, no later than that. As a matter of law, that's a statute of repose. You can't be told. There could be an argument about 106.3-118 as far as the statute of limitation goes on the promissory note. Sure, that might be told, but not the statute of repose.
Okay, sir, your time is well up, so we'll have to rely on your briefs for whatever other arguments you have. Mr. O'Neill, do you wish to be heard?
Yes. Good morning. May it please the court, my name is Tom O'Neill. I represent Shell Point Mortgage Servicing and Bank of New York Mellon as trustee. The full name is in the papers. A couple points I'd like to make at the beginning. I think Mr. Marley would agree. I've been nothing but courteous and professional to Mr. Marley as well as his wife through this entire process, and that can't be denied. So to make any kind of accusations that anything was done improperly, I think is incorrect. Because again, I've given him all the courtesies and professionals aspects that I would give to any other attorney. I gave to Mr. Marley as well as pro se. To begin with, I just want to say Mr. Marley has a very heavy burden to satisfy in this appeal. He must show that the single justice committed a clear error of law or abused her discretion. I don't think he's satisfied that in his papers. I don't think he's satisfied that here today. If you look at the purpose of the petition, I think it's well documented in the case law, and your honors are familiar with what that is used for. It's used sparingly in extraordinary relief, or for extraordinary relief, in circumstances that are extraordinary, exceptional circumstances where you need it to protect substantive rights where there's no alternative or effective remedy available to the individual. I think Mr. Marley points out that, in fact, he has had opportunities to raise his issues. This started many years ago, maybe 10 years ago, where he brought an action against the Bank of America, arguing all these foreclosure-type, wrongful foreclosure-type claims. Those were heard by a court. They were dismissed because they weren't ripe at that time. There was no notice of foreclosure that was served on Mr. Marley, and therefore they told him at the appropriate time, raise these issues. Rather than do that, rather than wait for a foreclosure to be commenced, he then filed a petition with the state court, Essex County, where he didn't name any respondents in that petition. He filed it with the court, took the position that I don't need to name any respondents. I automatically get this relief and the mortgage should be discharged. The court disagreed, forced him or ordered him to send out notices to various parties. He did that, and then our client, Shell Point and Bank of New York Mellon, appeared in the case. Bank of New York Mellon intervened in that action and then filed a motion to dismiss. I got involved somewhere around that period of time after the petition was filed, and I filed a motion to dismiss. And I told Mr. Marley during that whole process that his claims were incorrect and he was going down the wrong road, and I tried to convince him that a better approach would be to let a notice of foreclosure be served and then raise your claims in a wrongful foreclosure. He didn't want to do that, and he pressed those claims. The discharge of the mortgage. He argued acceleration. He argued various statutes saying that the mortgage is no longer valid. We litigated that for quite some time. Eventually, the court agreed with our position and dismissed those claims. Then I think he got involved, and it says this in his reply brief, with a litigant before this court. I think her name was Deborah Brown. She was an attorney, I believe, a litigant who was using Chapter 211, Section 3. He then learned a little bit about this chapter, and he decided to, in fact, try to assert his rights by filing that type of petition with the single justice. But it was an improper filing by Mr. Marley. It's broken down into kind of two categories. The first category is the main part of the petition, and he argued most of that today, and that is wrongful foreclosure type arguments: forgery, fraud, lack of standing by the mortgagee, defects in the chain of title, statute of limitations, statute of repose, which he continues to argue even though there's been a final judgment on those particular issues. I submit to this court that those wrongful foreclosure type claims do not present exceptional circumstances within the confines of the petition. He has other remedies available to him. He had remedies available to him. He could have filed a wrongful foreclosure action and raised those particular issues. Those issues are not proper for this petition under Chapter 211, Section 3. The second part of his, he tries to, again, wedge this into the petition by arguing vaguely in his petition that the land court did something wrong. And he uses words like systemic abuse, unauthorized actions by the land court, but I submit to this court they did no such thing. He cites the order of notice that was sent out by the land court, but the order of notice is authorized by rule. It is a form that is used that's approved by the state of the Commonwealth of Massachusetts, and there's an act. Act 1943, Chapter 57, that sets forth the procedure that should be followed, and it's a logical procedure, and that is we want to give notice to third parties because if they have rights under the Service Members Civil Relief Act, they should know about this proceeding, and it gives them the opportunity to appear. So the land court did nothing other than what it was supposed to do, and that is give notice. And in the Matt decision, I believe, resolves most of the issues that are being raised regarding the land court. The Matt decision specifically clarifies that the Service Members Civil Relief Act proceeding is separate and distinct from the foreclosure. Anything that happens in that action with respect to non-service members doesn't impact that non-service members' substantive rights. They still have all those rights, and the case clearly sets forth that proposition. So if he has a wrongful foreclosure argument, a defense, a claim, the Service Members Civil Relief Act proceeding doesn't do away with those rights or those claims. He could still raise those. So anything that was done by the land court did nothing to impact his substantive rights. So as a result, his petition was improper because it didn't satisfy the requirements of Chapter 211, Section 3. There were no exceptional circumstances. It wasn't necessary to protect substantive rights where there was no alternative effective remedy available to him. He has those remedies. He had those remedies. He simply did what he's been trying to do, and that is forum shop. And he mentioned it here today. He didn't get the relief he wanted in state court. He didn't get the relief he wanted in federal court. He then thought he would turn to the Supreme Judicial Court to get the relief he is trying to seek with respect to the mortgagee and his claims that there is no standing or no right to foreclose. As a result, I submit to the court that the single justice did not commit an error of law, did not abuse her discretion in dismissing this petition. It was properly dismissed because it does not satisfy the requirements of the statute. As a result, I submit that the appeal should be denied. Thank you.
Two questions before you sit down. The home was auctioned,
It was.
and who purchased it?
There was a third party that purchased it. I understand he was affiliated with Mr. Marley. Might have been his boss employed Mr. Marley.
So it's not the bank?
The bank did not, but
the bank did not purchase
he recently backed out, Your Honor, and he doesn't want to buy the property any longer. And so the bank was the second highest bidder, I believe. I didn't handle the foreclosure. I believe that they were the second highest bidder, so title could be taken by the bank.
Okay, and if the bank does in fact take ownership, does the bank intend to move for summary process while he is in custody?
I believe that they probably would do that. I haven't confirmed that, but that's a typical procedure, is once they take title, they want to get total possession of the property. I've been trying to work with Mrs. Marley on a solution to her predicament, and we haven't come up with any kind of solution. We were trying to work together. She put in an application to modify the loan. The lender, our client, came back with some terms, but her salary wasn't sufficient enough. She didn't believe to satisfy those payment obligations, and so that didn't follow through. So we've been working together. We haven't reached any kind of resolution. So the foreclosure was continued, and we did look for a response from the highest bidder. And again, I believe he backed out.
Any further questions? If not, okay, thank you.
Thank you.